Um, Thanks for joining us at the Registrars meeting with the real estate bar. And of course, you don't have to practice real estate to be here. My name is Brian Asmundson, and I've been Registrar of Land Titles and have been in this position since August of 2022. I have three people from our office here today, and I'll introduce Lauren in the green sweater shirt at the back. Lauren has been with our office for over 5 years. Her last name is Banks. She is none other than Elaine Keenan Banks' daughter, who many of you know was a long-term lawyer up here. And she's a paralegal with our office. We also call paralegals document examiners. That was the previous name. We take no offense, whichever term you want to use.
Rejectors.
What? Except rejectors. We have Hillary Wynn as well with us. She's waving. Hillary is an intern paralegal for our office. She's worked at corporate and now she's working at land titles until July of this year. Unfortunately, she's accepted and planning to go to law school in September at McGill Law School. And finally, we have Maurice Power, who is the longest term employee at our office. He is the surveyor. He's worked at our office since 1994. And if you have questions about plans, surveys, he's the guy that we sometimes direct questions to, or we try and get the answers from him before we regurgitate them to yourselves. Okay, I would like to start out by acknowledging that this meeting is taking place on Chiefs Dry Geese territory, the traditional home of Yellowknife's Denny First Nation, and also the traditional territory of the Talicho, along with other Indigenous nations who call this area home. And along that theme, we're going to be talking about two landmark cases, and both of them have to do with Indigenous, or sometimes referred to as Aboriginal land. And that is the Cowichan Tribes versus Canada decision, and the J.D. Irving Limited versus Wolastoqey Nation, which is from the, I think I might have the wrong citation. It's a New Brunswick case. So I think it's New Brunswick Court of Appeal. But I think it should say NBCA at the end. So there are two decisions that have come out in the past year, and they reached kind of two different results with respect to the private land and title to private land, which I'll get into at the end of the presentation. So we're going to give you an update since our last annual report, which was February 6th of 2025. I'll address some recent issues and miscellaneous topics such as condominium corporations. And finally, we'll finish with those cases. I suspect most of you have heard of the Cowichan case, as it's caused a little bit of an uproar and a little bit of uncertainty about what title to land in the foreign system. We're scheduled for an hour and a half, but I don't believe that we will take that long. And we want to allow for some questions and answers at the end and perhaps during the presentation as well. This event is being recorded. It's available via Zoom, I understand. I'm not sure how many people have signed in. But you're welcome to claim CPD hours for this presentation. Whether you're here in person or watching online, for whatever the length of the presentation is, it should be an hour or slightly longer. Okay. Some of these slides, I like to start out with just some facts, some interesting facts, maybe about the real estate market before we get into specific details. The Canadian market overall was down approximately 2% in sales last year, with real estate sales in Toronto and Vancouver hitting lows not seen in over 20 years. However, Vancouver or Yellowknife bucked this trend last year. From the numbers at our office, real estate sales were definitely up in 2025. And Caldwell Banker further reports it was the most active year since 2022. Our statistics at our office, which I'll show you more in a minute, seem to agree with this. Caldwell Banker says that the average price of sold properties in Yellowknife rose 6.5%. We do, keep some data information on prices at our office, but we don't compile statistics. But speaking anecdotally, it looks like most properties that I saw that crossed our desks did go up in value, particularly over a 2 or 3 year period of time. So values appear to be rising, good for those that own homes. Now, Caldwell Banker indicates in their report too that we are no longer a mining town in Yellowknife. We are a government city, and many of our mine workers living down south are outside of Yellowknife. And we'll see what 2026 does. I know Diavic's set to close in March of 2026. I can tell you our office is off to a slow start at the moment. Okay. Just to let you know a little bit about our staff, Matthew Yap is still the Director of Legal Registries, and pursuant to the Land Titles Act, he's the Inspector of Land Titles. I'm the Registrar since 2022, and our paralegal team lead, our Deputy Registrar as well, is Morgan Shaler. Morgan's been in this position for over 10 years, and our survey review officer, our surveyor is Maurice. He's as I said, the longest member of our staff. And we have 2 paralegals or document examiners at present, and that's Lauren DeBack and also Prosper Puwai. Prosper was here last year at the presentation, so it's Lauren's turn this year. We have a paralegal assistant up front, Yumera Mutula. Yumera was a summer student previously. And we have 1 intern paralegal, Hillary at the back, who I introduced earlier. Okay, we're off to a slow start, as I said, and so far in 2026, but we think things will heat up this spring again. Okay, every year I present some statistics on numbers that are calculated by most of these are done by our Northwest, our NTLS system online. And what I did this year is I did calendar year for January 1st, 2025 to December 31st, 2025. So for fiscal year 24 to 25, that would be from April 1st, 2024 to March 31st, 2025. I saw that statistic there and I didn't quite like it because I knew that we had a busier year last year. So that's why I stuck in that calendar year at the end. Yeah, it was definitely a busier year than the previous 2 years. We at our office were not expecting it to be as busy as it was. And I'm sure most of you noticed doing more real estate last year than normal. We appeared in the Northwest Territories again to buck the national trend of slowing real estate sales. And I'm not sure why that is, but I'm sure you guys have some theories as to what's going on or not going on in the market. Our personal property, I put some numbers on the side there. So a number of you do some personal property registrations, but it's usually done all online. And we have contracted out to an organization called Unisys in Nova Scotia. They run our system, they run Nunavut system, Yukon, and all of the Atlantic provinces. Our registration numbers, and these would be for basically anything with a chattel number, among other things. So vehicles, Sometimes mobile home, of course, when they're not affixed to the property. And numbers are similar to the year before. Searches are way up though for some reason. They're up about 2 or 3,000. Not quite sure why so many people are doing searches. Okay. Oh, this is a statistic that I present every year. And we put in there the percentage of submissions that were submitted correctly by law firms. And the top law firm has an 85% success rate. Firm number two, 81%, and overall at the bottom, when we average all the submissions, it works out to 72%. So I haven't identified the firms in question, but if you want to know where your firm ranked or what percentage you got, happy to tell you if you want to email me or talk to me privately.
Yeah, it's 15% of my documents she registered, so.
Okay, and then we do this graph. Nobody's objected so far, but real estate transactions by firm. Of course, it's some of the larger firms sometimes do some of the more commercial transactions. So these are percentages of the real estate transactions based on what we see, based on the numbers at our office. If your firm's percentage might have gone down last year, based on our data, this doesn't necessarily mean you did less business. The overall number of transactions was quite a bit larger in 2025. So there's a bigger pie to share. Now under other, you'll notice that's quite huge. That's 40%. That includes First Canadian Title, F&F Canada, and they both do a lot of discharges. Some of the banks through FNF actually register some mortgages against properties directly. They actually do my opinion, they should probably be using law firms because we're finding they get a lot of rejections, and not just that, but they're not very timely. They'll sometimes have a mortgage that they're registering that was signed last year. So it's but anyways, it's none of my business, I guess. But we also included the odd law firm in that 40% number that they do very few submissions. Like I think we actually put a company in Calgary, they do just foreclosures. Forget what her name is offhand.
Hendrickson?
Yeah, Hendrickson's in that number, yeah. Okay. Turnaround time. Now, this is, of course, important to yourselves and important to our office as well. We have a goal of 2-day turnaround. So from the time your documents are submitted until they're rejected or accepted, we want to do that in 2 days, ideally. Last year, overall, we were at 4.4 days. So we were above what we want to be at. We started out the beginning of the year at 2.2 days, and then we went to 2.6 days. And of course, what happens, starting usually in June, we start getting a lot of submissions and we slow down. We can't keep up. And so for July to September, we were at 7.6 business days turnaround. And then October, the last quarter of the year, we were at 3.7 days. So yeah, got quite busy in the summer. It was our busiest summer in about 3 years. We still use the system called the NTLS system. It's a system where you can look up real estate online. Most everybody does. We charge, I believe, $10 at our office to do a search. If you wish us to do a search, but if you do it online, I believe it costs us $4. So we are trying to encourage people to do their own searches. And you don't only have to be a law firm to do the search. I think a lot of the banks all have a NTLS account and they do searches and whatnot. So that our system, our NTLS system is fixed, or we have the GNWT is now our developer. And they look into any problems that we have with the system, any glitches. And I want to thank everybody in the room for when titles aren't available. Often somebody lets us know, they send an email to our land titles account. That's what we want to see. We have had, and we do get glitches to the system, anything from, it could be a government-wide problem, or it could be just a problem with NTLS. So when we get those, we try and look into it immediately and try and get the system up and running, or try and get our computer people to get the system up and running. So thanks for that. We'd like to go to a more sophisticated electronic system in the future, but funding, of course, is an issue with respect to that. Okay, recent issues and miscellaneous topics. I usually present it every year. I try and come up with some issues and topics that have come up over the past year, and which I might not have touched on much at all previously. Some of what I might discuss will be a refresher for many of the experienced real estate lawyers in the room, but I thought it worthwhile bringing up to the audience here. Condominiums. I recently attended myself legal education of the Society of Alberta presentation by Roberto Nos on condominiums in Alberta. I don't know if anybody else attended that one, but he's kind of the condominium expert, or one of them in Alberta. There's many people that specialize in that area. And it's interesting. There are a lot of similarities, by the way, between the act in Alberta and the way things go run in Alberta and the Northwest Territories. I believe initially we probably got our condominium act largely from Alberta. Ian might be able to tell me that. He's not sure. But looks like there's a lot of similarities anyways. And I just was going to mention this. Sometimes I know Leanne did a termination of a condominium corporation recently. And I did see there's the odd little precedent maybe, or something you could use as a precedent in the regulations in the Condominium Act for Alberta. So even, I think they even have sort of they've got a set of bylaws in there too, I think, that kick in Alberta. If you don't do your own bylaws, I think they have a standard bylaws that kick in. So I didn't do too much snooping, but I just had a little bit of a look. And we don't have some of that stuff in our regulations, but if you're looking for precedents and stuff, you might want to have a look and see what Alberta has back there. So I won't read this because most of you are aware of what a condominium is. I'll just flip on to the next slide. I do want to touch on the basics of how a condominium corporation is formed. It's formed as per Section 12 of the Condominium Act, which is on the registration of a declaration and the plan. The plan would be the survey, essentially, but it's always a new plan. And Maurice at the back would be the one looking over the plan. And the plan would, if I'm not mistaken, replace another plan that was either in fee simple, or it might have been for bare land. Does that sound right, Maurice? Yeah. So with the registration of the plan and the declaration, the condominium corporation is formed. And what I decided to do this year, since sometimes people ask, well, more the public than the lawyers. I think the lawyers mostly know where to look, but I've listed all of the condominium corporations that we have on file in the Northwest Territories. And there is, I think I counted 80. You'll see that there's about 67 that are listed in Yellowknife. At least one of them has been deregistered, I believe is the term or whatever. I'll get to that in a minute. But most of these are still functioning. And there's some in Inuvik, Hay River. And I thought there was one that had a quad in front of it, so I'm not sure where that is, but it appears almost all of them are Inuvik, Hay River, and 67 of the 80 are in Yellowknife. Okay. So with a condominium corporation, you have a unit number and a plan number. So if you're looking for it in NTLS, that's all you would enter. There's no block for condominiums, so it's just a unit number and a plan number. And each condominium title, so each unit would have on the back of its title, the registration of the bylaws and the declaration. The plan number would be on the front of the title. Also, not so much with lawyers, but we get members of the public every year calling and they're saying, oh, I was looking at corporate registry for my condominium corporation and I couldn't find it. Well, that's because it's not at corporate registry. It's listed at land titles. It's formed at land titles pursuant to section 12 that I just referred to. And there's actually no annual, there's some annual requirements. There's a requirement for an annual general meeting. There's some requirements for a budget on a yearly basis. They're all set out in the Condominium Act, but they don't get filed at our office. So you need to look at your land titles. And also on the back of your title would be the bylaws. The bylaws get registered on every unit number as well. And whether it's old bylaws or new bylaws. Quite a few of the condominium corporations in existence have amended their bylaws. So, and usually, not always, but usually when you do an amendment of a bylaw, it's a repeal and replacement. Because I think most lawyers find it just easier to redo them all from the get-go, just do a repeal and replacement. Yeah, Ed?
I have a question about address for service for condominiums.
Yes.
So I send notices every year to Northlands, and they all come back because their address for service in the declaration has never been updated. How would you update the address for a condominium corporation at land titles?
Good question. I actually have that specific form in there. And I'm gonna tell you in a minute how to find that form. Now, it would normally be done by, could be done by the lawyer. There's nothing stopping a lawyer from filing the updated address, but normally I would think the president of the condominium corporation that was elected should be the one filing that and keeping that up to date. But yeah, I do have it set out in here, a precedent for that, and I can tell you where to find it on our website. Okay, condominium fees. Normally, your share of the costs is determined by the declaration, which sets out both your percentage ownership in the common property and the percentage you must contribute to the common expenses. And insurance on a condominium is usually the responsibility of the corporation. That is insurance for damage to the units and the common property, and also occupiers liability insurance with respect to the common property. Now, a condo owner would need, or I think it's highly recommended that you buy your own insurance to cover your personal property, personal liability, and perhaps any improvements made to the unit. For example, I don't know if stove oven, if the place burnt down, if that would be covered by the condominium corporation or any improvements. Is that standard advice when somebody buys a condo, you tell them to take out their own insurance or just leave that to them? Yeah.
I was formerly treasurer of Northern Heights, and it is mandatory when you buy there that you have water escape liability, because you're responsible for the first $50,000 of damage if your bathtub.
Okay. That was
That's something that I only learned that after I bought my unit.
Okay,
And it's something that a lot of people don't know, so a lot of economy corporations have specific obligations on individual owners. Insurance, they should.
okay,
Additional loss assessment endorsement.
okay. We've got two lawyers in the room that recommend that you buy insurance, and you might wanna check with your condominium corporation. Maybe the board of directors will direct you on what you need to have covered in private insurance that is not covered by the other insurance that the condominium corporation would have.
It's cheap too, like I pay $500 a year. for insurance.
Okay. Okay, so it looks like it's recommended that you get your own insurance in addition to the condominium insurance. Although in most cases your condominium fees are based on the percentage of your ownership, this is not always the case, nor are all condominiums the same. Northlands, which we were just talking about, is what we call a bare land condominium. And I'll get into it in a minute, how they split the expenses for Northlands. Also, in the past year, we did have a condominium where it came to our attention that the unit factor appeared to be incorrect based on square footage. Ultimately, if a party believes that division of ownership of the undivided interest in the common elements is not divided appropriately, they can seek to amend the condominium declaration. That's set out in section 5 of the Condominium Act. And it involves, unfortunately, several steps. Our office would not be involved as the company that made the declaration technically made the error. And we cannot always assume when we see the plans, when Maurice sees the plan, we can't always assume that the condo fees are based on square footage. And I mentioned Northlands. So for Northlands, which is the biggest trailer park, I think, in town, they have 259 trailers. In their declaration, it states that the owner of each unit shall have a 1/259th undivided interest in the common elements and shall contribute to the common expenses in the same proportion. So condo fees are the same for each and every unit in Northlands, as far as I know. And that might be the case for most bare land condominiums. There's not a lot of them, but there are some. Of course, Northlands has 259 units. We have this pamphlet at our office, and we've actually got about 3 or 4 boxes of this. It's a little bit dated, but we haven't done that many updates to our condominium act, so I think it's most of the information, it's in layman language, so the average person can read it. You're welcome if any lawyers come to our office, you want to grab a bunch of these for the condo deals that you do, or if somebody from a condominium corporation who's president of a condominium corporation wants to get a bunch of these, that's fine. Because we often get asked questions about condominium corporations, and there's only so much we do with the Land Titles Act. We don't really get into fights between condo owners. We don't make sure that the financials are in order. We don't make sure that the AGM is held on a yearly basis. So I'm happy to pass out these pamphlets. You can grab probably 100 if you want. Oh, one thing that we do, just to make you aware, we will do what's called a status letter. I do at least 4 of these a year. And what usually happens is a banker wants some confirmation that the condominium corporation is still in existence. So basically kind of the equivalent to good standing at corporate registry. And they often can't figure out why they just can't find this at corporate registry. So I'll do up a letter. This is just a a brief summary of the contents, of the major contents. We'll put in the president of the condominium corporation, the name. And the name of our condominium corporations, it's not real sexy, but it's for Yellowknife condominiums, it's Yellowknife Condominium Corporation number. And then we use the next number that there is, so I think we're at 67 now, so the next condominium corporation created will be number 68. And Anubik is the same, we just put Anubik at the beginning. So, yeah, it's usually the treasurer or the president of condominium corporation that wants this letter. I don't know if you guys as lawyers sometimes get asked to provide some sort of proof from time to time. We charge $30 for this letter. So if you want to direct them to our office instead of doing something yourself, that's fine. Condominium corporations, unless they've been terminated, are considered to be active. So as I said, there's requirements for the annual general meeting, the budget, and some other items that are mentioned in the act. But our office doesn't monitor those. We are considering codifying the concept of a condominium status letter that attests to and can be relied upon the existence and legal capacity of the condominium corporations. So we're considering fixing something up that we might just have for each condominium corporation at our office. We would set a fixed fee for this in the regulations if we do this. So there's no requirement for any annual filing, as I said, unlike a corporation and corporate registry. But we might, like I said, set up an annual disclosure package to be filed. I think that would help a lot of people out because we seem to get a few questions. One is the current address of the condominium. Frequently, that's not kept up to date. The current directors, the location of the condominium's records, and the place of the corporation's annual general meeting. And we might waive this requirement if the number of unit numbers in a condominium are 6 and under. Termination of a condominium corporation. Just as you can set up or convert an apartment or something into a condominium corporation, you can also terminate it. And I said to some of you at the beginning, Leanne Dragon did this in the last 2 years, so she's the expert now. You need a vote of 80% of the people holding the common elements, or such greater percentage as may be specified in the original declaration filed in the condominium corporation. And you need the consent of persons having registered claims against the property created after the registration of the declaration and plan. It's fairly rare, I think, that a condominium corporation is terminated. The one that is terminated, I think that Leanne did, was corporation number Yellowknife Condominium Corporation number 51. It's still on our list, but it's no longer in existence. It was terminated pursuant to the above section. And when it's terminated, it simply reverts back to fee simple title, the same fee simple title that it was prior to becoming a condominium corporation. Reese, did you have anything to add there? Or
There's been about a half dozen, I think.
half a dozen? Okay, so there might be more on this list that have been terminated. Oh, here we go. Here we go to the change of address. I don't think that a lot of condominium corporations, as Ed Goldberg just shared with us, a lot of people, once they form is the president of the company or whatever, they don't realize that the only address, since everything's registered at land titles, often it's the address in the declaration that we have, and we take that to be the correct address, but it's the responsibility of the board to file a change of address, which we could then register on the back of all of the unit numbers. Lauren, is there a fee for this or is it free?
Believe it's free.
Okay, so I think it's, that's what I'm thinking, it's free because I know you can change, a notice of change of address for anybody filing, a change of your address if you'd want. If you move, but you're retaining your property and you want notices to go somewhere else. You can file it at our office for free, so I think you could file this for free. Now, this form, this is a suggested form that we did up by our office. And you can go to the main government of the Northwest Territories main page. And then where it says search for government websites, you stick in land titles. And then it'll take you to a number of forms that our office has done up. Oh, sorry, on the next page, I did give you
Can
the
I ask
structure.
a related question?
Yeah.
Why does the condominium not require an address? It's like one of the only land title documents that someone can file without an address for service of the claimant.
Lauren, write that question down. We'll try and get back to Ed on that. That's a good question, and maybe that's something we need to work on.
I mean, that's, so when I do tax letters.
Yeah.
For municipalities, we have to look up all of these registrations. And then we have to track down the address for service because they're not in cash themselves.
Yeah, okay. Good question. The only thing I'm gonna say, we probably need to do some updates to our condominium act, either in the legislation or perhaps we can deal with that one in the regulations, in which case it doesn't have to go through the legislature. But maybe that's something we need to look at. Gonna see if I'm on the. Oh, it doesn't show up, but that's I did throw in a little link there. Gonna get out of it, I see it on my site, so, which, as I said, you should be able to get a number of forms that we have on our website or on the land titles portion of the Government of the Northwest Territory website. Some of them are in the regulations, in the land titles form regulations. Some of them are not, but some of them, all of them are somewhat frequently used, so. Okay. Oh, yeah, I just think I missed that. Oh, I missed this notice of lien. In this form, we also have at the same website. And quite frequently, somebody doesn't pay their condo fees for a month, for 2 months. Usually it's a couple, 2 or 3 months before somebody on the board decides, hey, we better file a lien against this unit number in the condominium. They haven't paid condo fees for 3 months. And we want to make sure that if they proceed to sell the property, that the buyer has noticed that the fees have to be dealt with. So you can file a lien. And there's also all in the forms too, there's also a discharge of notice of liens for condominiums. We do get a 4 or 5, maybe even more than that on a yearly basis. That sounds about right, Lauren?
Yeah,
Yeah. So. I'm not sure if you don't file it, I think still, when you're doing a real estate sale of a condo, I assume you would look into. Whether all the condo fees are paid, so perhaps the notice of lien is a little bit of a duplication, is it?
I think it's only important if someone wants to refinance their property. But on a sale, if you didn't check the comments.
Yeah. I guess one of the advantages though is it does, once it gets registered, the unit holder gets notice that, hey, this has been put on your title. So maybe they take it a little more seriously.
Well, if the tenant is supposed to pay the condo fees.
Yeah,
But that's the form I was talking about. There's no address for service.
Well, I might have cut it off a little bit, but below, yeah, when it say Yellowknife condominium number.
Okay.
We'll look into that. Okay, here's something that's caused some angst to a lot of lawyers in the room. And that is we've discovered in the last year that Scotiabank Standard Form Mortgage Instrument number 201,090 in clause 29.01 contains the following clause. It says if there is a conflict between the terms of the charge and the terms of the agreements will prevail to the extent of the conflict. So in most cases, when somebody gets a mortgage from the bank, from the Scotia Bank, they throw in, this is a frequent standard form mortgage that is thrown in. And the purpose of the standard form mortgages, again, is to reduce the size of the mortgage so that you only have to have a 2-page mortgage and with the main terms in the 2 pages, and then the standard form mortgage is just like it says, a standard form mortgage, so. So that is caused a lot of problems, because we take the position at the land titles office that the terms of a mortgage, at least when registered initially, need to be in the documents in the submission at land titles. So if there's no other agreements prevailing over this, if there's other agreements, that do prevail over this, these need to be filed, or alternatively, we would accept if this clause is stroked out. And I know some of the law firms do enclose behind the 2-page or mortgage document, if they might attach the standard form mortgage document and then stroke out clause 29.01 if it's not applicable. If there is a personal credit agreement that overrides the mortgage, you can put this right behind the mortgage. And we have started a practice at our office of putting these mortgage agreements at a different place in our office. So we don't actually PDF them. If you search online, you won't see it, because often they contain perhaps the social insurance number, perhaps the date of birth. Obviously, your clients don't want that online. Nobody does. So that's what we started doing. I've checked, just to let you know, our practice is maybe not Canada-wide, but at least in Alberta. The Alberta Land Titles Director also says that they also take the position that the mortgage document should be fulsome. And they want all of the terms, at least initially, in the mortgage filed at their land titles office as well. Okay, that's our land longstanding position. Couple of problems in the last year. One is with required corporate status. This is nothing new or unusual, but a transferee mortgagee must be a legal entity capable of holding and acquiring an interest in land. So before any instrument or caveat is registered in favor of a corporation, we require evidence of the legal existence of a corporation. Now, we do check. We have access to Cross in our system, so we do check do a quick check at the corporate registry system, type in the name, and if it shows that it's in good standing, or then that's fine. You don't have to provide necessarily proof if it's a good standing. If it's a Northwest Territory Corporation, that is, if it was incorporated in the Northwest Territories initially, it's okay if it's not what's called in good standing, so long as it's not been dissolved. So we recognize sometimes companies are a month or 2 months behind in filing, doing their annual filings. So it's still a corporation, it's still in existence even if they're a month or 2 late. But a corporate, I'm just gonna emphasize, a corporate entity was chosen by someone and they hold a land or they hold a mortgage. Therefore, it's the responsibility of the directors of the corporation to ensure that they file the necessary documents at corporate registry or have their lawyers do so. Now, we take a little bit of a different stand with a corporation that is what's called an extraterritorial corporation. So it's registered, the most frequent example is a corporation was incorporated in Alberta and also has what's called extraterritorial standing or extraterritorially registered in the Northwest Territories. For these corporations, if they're doing a transaction at land titles, they must be in good standing in the Northwest Territories. If they're not in good standing, you need to either wait until they are in good standing or provide a notarial certified certificate of status from the home jurisdiction. Now, we've begun because some of the corporate registries across Canada have started changing and they will only issue electronically certified documents from their jurisdiction. And I think Alberta is one of them. And I think Nova Scotia might be another. So we've started accepting these, but we ask that you print them off and submit them. And maybe add a note, just even a sticky note, just to say this jurisdiction only issues electronically certified notarial certificate of status. And if it's within the 30 days of filing and you have proof that they're in existence, then we would take that. Theoretically, we used to be wet ink always, and we were trying to not go to the new system, but we have to evolve. And we realized too that we can double check that if we wanted to by paying the fees to the other jurisdiction. Usually where it's an electronic certification is done from another jurisdiction, it's in the certification's in a different color. So if you could print it off in color, that would also help us just confirm that it's valid. Okay. Alterations, insertions, and deletions. This has always been an issue here and there with our office. Where an instrument that grants an interest in land appears to have been altered so as to change the effect of the instrument, the alteration should be authorized. Alterations which appear to have been corrections of minor typographical errors do not have to be questioned. And I'll get into what's minor and what's immaterial and what's material. But the practice has long been established that initials of a party are acceptable where the alteration is made, as long as it's obvious that it's the initials of the grantor of the instrument. An erasure, deletion, or other alteration of the document is presumed by our office, unless there's evidence to the contrary, to have been made before the execution of the document. So I think in years practice, I remember doing real estate transactions in Alberta. And at that time, I don't think there was this presumption. I think we initialed everything. I think probably you did it that way in the Northwest Territories at one time. Is that correct? And now we've sort of gone to this presumption, so. Again, it's up to the law firms what they want to do. We'll give them the benefit of this presumption. Of course, as a lawyer acting for whatever side you're acting for, you'd want to make sure that the parties that sign it are contractually bound. One exception or one time when we can sort of see that something needs to be initialed is when a document is rejected and then resubmitted with the alteration to the document being evident. It can become certain to us that the alterations have been made after the execution. In that case, who can amend the document depends upon the nature of the instrument. And this is where we break it down. I'm just going to talk about two types of amendments: immaterial amendments and material amendments. An immaterial amendment would be any alteration below the signature line of an instrument. an amendment to the headings of an instrument or the insertion of something like a postal address in a transfer. So those we're not concerned about initials. Material amendments would be something that varies the rights, liabilities, or legal positions of the parties, varies the legal effect of the instrument, or otherwise prejudices the parties bound by the instrument. So an example would be a change in the principal amount of the mortgage, an amendment to the interest rate, or an amendment in the name of the party to an instrument. We've considered those material amendments. I was going to, what time is it here? I'm gonna skip this joint tenancy part. I'm just gonna say, that often people don't rush to try and change the tenancy and title. Not a good idea if you think you might die soon, because when we get an application of surviving joint tenant into our office, we will take it and we will process it. The onus is on the joint tenants to change it before death, or do up a separation agreement and
Excuse me, but how does that coincide with the common law? The common law, much simpler to.
exactly, the common law talks about the severance of the four unities, which I think in law school, we all kind of remember that was a bit of a difficult subject. So you are free to go to court, for example, if you did a will and you severed, or you made the will and you transferred your land in joint tenancy to somebody else afterwards. Does that sever the joint tenancy? It might.
But I don't understand why a joint tenant couldn't file a caveat
Oh, they can.
giving notice
That-
to terminate the joint tenancy and land titles.
Yep. That would be the trick. If you don't agree that you hold land in joint tenancy, a caveat should probably be registered right away. Like I've seen 3 cases at least in the last year where people have been common law, usually common law or married, it doesn't matter. And they're no longer in that relationship, they're separated. And but and one party, of course, has moved out of the sometimes in one particular case in Yellowknife, the guy died in his home. And the spouse or the other joint tenant lived in Nunavik. So all of a sudden you got a situation, and they've been separated for 20 years. They've done nothing for 20 years to get title straightened around, and it's not that hard. But they've done nothing for 20 years. So what happened was, in that particular case, is the sister of the deceased knew that the separation had been long-term, and she rushed to hire a lawyer, filed a caveat right away. I mentioned this last year, yeah, filed a caveat, and they must have got things straightened out, because the caveat I saw, the house got sold, the caveat came off, and they must have, I think they reached at least an agreement that the money was gonna be sitting in some lawyer's trust fund until they got things squared away. So you're quite right about the caveat. Yeah, that would be the solution. Usually most,
But didn't your last slide say you'd only accept a transfer?
we,
Let's read it.
oh, you can't transfer. We had in the last year where someone tried to transfer from themselves as a joint tenant to themselves as a tenant in common. And we did not accept that. We looked at our act very closely, and for a number of reasons, we do not have that ability in our act. But I mean, it's something that we can do in the future. But what this person was really trying to get out of is they didn't want to confront the other joint tenant who no longer lived in the house and they wanted to give away the property without, notifying, without getting into a confrontation with the other joint tenant, really. Now BC would allow something like that in pursuant to their legislation. Alberta would require at minimum, they have section 65 of their Land Titles Act. They require that you at least give notice 30 days in advance before you make an application to land titles to change it from joint tenancy to tenancy in common. So whether we'll change that or not, I think we might want to. Seems to be getting to be a bit of a problem, but it's also up to the person to straighten out their own title and their own affairs. Just wanted to point out the Builders Lien Act is now in effect. And it replaces the Mechanics Lien Act. It came into effect on September 1st. But how it's going to work in the transition is any contracts before September 1st, 2025 would be governed by the Mechanics Lien Act. And also any services or materials under those contracts before September 1st, 2025 would be the Mechanics Lien Act. So both acts are technically still in place, and you need to look at the contract date to determine which act applies. We had one builder's lien filed so far, and then it got rejected and it never did come back in. There's a longer period for filing under the Builders Lien Act. It's 60 days, depending upon whatever the event is that starts the 60 days. So it must have got settled, and I think that's why it didn't come back in. This is not news to most of you, just checking on the queue in land titles. And so you can't read that down there, but I just checked this morning, and what it says this morning is, it says first review and date booking completed to 2026 January 23rd. And the last accepted package was 2026 January 22nd. So we've done first and second review on all of our packages up to some date on the some hour on the 22nd. I don't know if we finished all of the 22nd matters or not, but we're pretty caught up to date right now in January. Okay.
I have a question on those. So we get a notice saying our package is registered. Does that mean we're okay to come and pick it up? Because I've gone right away when I'm waiting for something, oh, not ready. So I'm just wondering, like, need like an hour after that notice goes out automatically, or what's the expectation?
I think we usually tell people to come in the next day. Lauren, or
It's typically ready within. After the accept button is hit. If Morgan or Brian are quick to put it in the scene. Should be great. If things are kind of.
So.
It might be
At least an hour.
typically 10-15 minutes, but sometimes it might be an hour or two.
Yeah, it's
You
just
might not have
sometimes-
find out pages, so sometimes it's even longer.
sometimes you're waiting on something for a while.
Yeah,
Anxious to get it.
typically.
Yeah.
Very quick after that's accepted. But not always.
okay, well, I've got two cases I'm going to go through, and then that'll be it for my presentation. I'm going to go through, just to give you a sort of course, a brief overview. The Cowichan decision, Cowichan Tribes versus Canada, is 863 days. The Cowichan trial lasted for 513 days. There was some breaks in between the trial dates, but from start to finish, it was 11 years. I think it's considered the most extensive trial in Canadian history. The property disputed is basically in Richmond, BC, which is the airport where everybody's plane lands when you're going to Vancouver. So there was a headline that I read, said, what is a Cowichan decision and why is everyone so worked up? which is quite right. Um. It's considered a landmark decision by the Supreme Court of British Columbia, recognizing Aboriginal title for the Cowichan Tribes and several affiliated First Nations over lands located in Richmond, BC. It's roughly 750 to 800 acres of land. Some of the land that was recognized was submerged too, which up in the air, whether that can be recognized or not, but they did recognize it. It was declared that the existing fee simple titles originally held by Canada and Richmond, the city of Richmond, were defective and invalid to the extent that they overlapped Aboriginal title because the Crown's earlier grants unjustifiably infringed on the Indigenous title. Now, I'm just going to give you a high-level overview, but I did want to mention that one of the reasons the trial was so long is the Cowichan First Nation had to prove sufficient occupation of the land to establish title at the time of the assertion of European sovereignty, and they had to prove continuity of occupation where the present occupation is relied upon, and exclusive historical occupation. An important part of the facts that you won't see in this sort of summary of the head note is apparently in 1853, Governor James Douglas told the Cowichan peoples that the Queen had given him a special charge to treat them with justice and humanity, as long as they remained at peace with the settlements. Justice Young, the trial judge in this case, found that while the promise fell short of a constitutional commitment, it bore the hallmarks of one, thereby engaging the honor of the crown. As part of this promise, Government Douglas appropriated Indian settlement lands, including the Cowichan title lands, from the crown's land disposition processes, with the intention that they would eventually be converted into Indian reserves. At that time, Cowichan continued to occupy their village and surrounding areas. However, the lands were never established as an Indian reserve. In time, the lands were in fact sold to settlers without Cowichan's knowledge or consent. Because the occupied Indian settlements were appropriated and thus could not be sold, Justice Young found that most of the crown grants in the Cowichan title lands were made without statutory authority. Justice Young also found that the crown grants were made without constitutional authority because the legislation limited the province's ability to sell the lands without first dealing with the Cowichan's interests. So that's a little bit of important history here, I think, yeah, why the decision was made. Many titles within the 732 to 780 acres are either privately owned or leased because they're very close to the airport. While the court did not cancel private landowners' titles, and apparently the Cowichan did not seek that remedy, it did hold that Aboriginal title is a prior and senior right to other property interests where established. And I don't think we'd ever heard that in a decision before. The court suspended its declarations or its rulings for 18 months to allow time for negotiation and orderly transition agreements between the parties. But it's been appealed by multiple parties to the Court of Appeal in BC, and many expect it to go to the Supreme Court of Canada. This ruling is considered precedent setting because it's the first time a Canadian court has granted remedies, potentially invalidating Crown granted titles based on Aboriginal title finding, and highlights the constitutional priority of Indigenous title under Section 35. of the Constitution Act. The earlier crown grants were considered invalid as they infringed Aboriginal title, and therefore the private title owners could not rely upon their titles. Now, in that case too, I should say in Cowichan, the title owners actually did play a part in the litigation. Whether that was appropriate or not, that decision was made, but we'll see. It's appealed and probably up to the Supreme Court of Canada. Now, I could get into it and there's lots of courses on it. You can read more online. I'm just gonna leave it there because I'm gonna go to the next case, which is quite a bit different. And this case is J.D. Irving Limited versus Wolastoqey Nation. And yeah, it is a citation here that I see is New Brunswick Court of Appeal. So I had it wrong at the beginning, the citation for it. But on December 11th, 2025, the New Brunswick Court of Appeal released a major decision addressing whether Aboriginal title can be declared over privately owned fee simple land in New Brunswick. The court held that the declarations of Aboriginal title cannot be made over land held in fee simple by private owners. In this case, the case arose from the Wolastoqey Nation's broader Aboriginal title claim, which included Crown land and certain privately held interest owned by large industrial forestry companies. And J.D. Irving, which is a pretty big corporation in the province of New Brunswick, was involved. The industrial landowners appealed after the lower court refused to strike parts of the claim. This case involves title in the entire western half of the province was being claimed, entire west half of New Brunswick. The Court of Appeal categorically rejected the possibility of declaring Aboriginal title over privately held lands. And they also reasoned that such a declaration would create two competing exclusive ownership interests which cannot legally coexist, quite contrary to the other decision. It was also concluded that recognizing Aboriginal title over private land would undermine reconciliation and destabilize property rights. The court held that the industrial defendants, including J.D. Irving and affiliates, cannot face claims seeking a declaration of Aboriginal title to the land they own, and therefore those parts of the claim were struck. They did allow for the compensation claim against the Crown to continue. The First Nation can still pursue a finding of Aboriginal title, which would support a compensation claim against the Crown to the lands that became privately owned. The Wolastoqey First Nation disagreed with this decision and is seeking leave to appeal to the Supreme Court of Canada. So we now have both the Cowichan Tribes decision and this case, which appear to be heading upwards to the Supreme Court of Canada. Yeah, the BC Supreme Court said that Aboriginal title can exist even over privately owned, subdivided, and urban lands. The New Brunswick Court of Appeal says no. Completely two different decisions in this area. So stay tuned. I don't know if we'll get our decision in the next year or two, but in the Torrens land system, we like to tell people that your land is guaranteed and there's an assurance fund that is paid for each transaction in the event that a mistake is made by the land titles office. So this is interesting and concerning. So that concludes my presentation.